Thank you for being here. I'd like to thank our board members that are here. I see that Steve Simler's here, Barb Smith, Karen Law, Mary Mathis, and I don't think I missed any, have I? Oh, there's Deneen Stewart. So welcome. We're glad to have you here, board members. Thank you. This is important training for us. I know you will find this training very informative because I know that we have an outstanding presenter today. Our presenter for this morning's session is Michelle Cooper. She is board counsel for South Harrison. And we're trying to determine this morning how many years. We think it's approaching 20 years she's been board counsel, so she knows South Harrison well, and she's been involved in a lot of affairs here. And she is a partner in Lewis Kappas, a noted law firm in the state of Indiana. So we're just very pleased and excited to have Michelle Cooper here to meet with you today. So welcome.
Well, thank you, Dr. Lee. I appreciate that. So I want to first of all say, I've been told I need to try to remain stationary up here because they're recording this, and I'm a walker and a talker, so that's going to be a real challenge for me. So if I start walking around, so one of our associates, Grace Lundy's here with me today, and she's going to be co-presenting, so I'm going to have her, trip me or something if I start to walk around and get out of sight of the camera view. But we're real pleased to be here today. Dr. E let us know you were having professional development, and he wanted us to talk with you all about discrimination, harassment, retaliation, and primarily with a focus on one particular category of these types of claims in the area of race. We are seeing an uptick in the number of race claims. If you ever hear any lingo thrown around, somebody talks about a Title VI claim being filed, what they're referring to is Title VI is a federal law that covers racial discrimination, harassment, and retaliation in the context of education. So all of these race claims now, if they get filed with the Office of Civil Rights, which is the federal administrative agency that implements that particular federal law, all of those cases are being investigated both at the regional Office of Civil Rights, or you hear them called OCR a lot. They're a division of the U.S. Department of Education. They have regional offices all over the country, but then their primary headquarters are in Washington, D.C. And so all of the Title VI cases right now that get filed with OCR are being investigated at the regional office and then ultimately sent up to the highest level in Washington, D.C. for additional review. So what does that mean? It means that the federal government is highly scrutinizing these claims. They're looking very closely at them, and they're making sure that everybody is dotting their I's and crossing their T's and being compliant with the law. So it's really important for all of you to understand what your obligations are as employees, or some of the board is here today and they have a role in the internal investigation process, primarily to hear appeals. And so they're here today because they play a really important role under your policy for race discrimination as well. We're going to focus really today more on students and student type claims rather than going down the personnel avenue. There is a separate federal law that governs race discrimination claims with regard to employees. But today our focus is going to be with students. So we've got about an hour with you. One thing I would ask is that if there's a question that any of you have, I want you to ask it, and don't be afraid. One of the reasons why Grace and I decided to stand down here and talk with you all and not get up there on the stage is, we put our pants on one leg at a time just like everybody else, and we want everybody to feel comfortable and that you can ask any questions that you have. You can pose a hypothetical if you like, and we'll run through those. I know Carolyn Wallace asked me this morning, she said, oh my gosh, if you start telling stories, are you going to start telling stories about us? And I said, actually, the cases I have going on right now don't involve this district. So we have good fortune. We work with schools all over the state of Indiana. So I go as far north as Gary Schools, which is almost across the line into Illinois at Exit 3. And then also south, down here in Gordon, Clarksville, New Albany, Floyd County, Greater Clark County, you know, a lot of the southern districts that we touch, and then everywhere in between. So out of the 270 some public schools in Indiana, we're touching over 200 of them in our firm. So we see a lot, we deal with a lot, and always like to have the opportunity to come out and, you know, meet with everybody in the district when we can, and just try to educate you so that we keep you from having to get to know me on a more individualized level. Because it's never good when, usually it's not a good thing, and when you have to meet me and you're not on the board or you're not a high level in administration. So let's get started here. So what is discrimination and retaliation? So we're just going to kind of break this down to the starting level. So when it comes to discrimination, we're talking about treatment where you're treating somebody individually differently based upon some protected status. Now, I know that one of the words that's thrown around a lot is bullying, harassment. You know, in today's world, if somebody says something that another person doesn't agree with, they say, oh, well, you're bullying me or you're harassing me. Well, they may feel that way from an emotional perspective, but for it to rise to the level of a legal claim, the conduct has to be occurring and be directed because of a status that's protected by federal law. So what are those statuses? Well, you see them listed up here on this slide. So race, color, national origin, sex, which now our federal courts have determined includes gender status, sexual orientation, and gender identity. And then disability, age, religion, military status, ancestry, and genetic information. So if the reason why the conduct is occurring is because the person's being targeted based on one of these protected classes, then that's what's going to trigger a claim. So a person who's just not a very nice person, well, that may not be a good thing, and it may be a violation of other conduct policies. It doesn't necessarily mean it's going to be a legal claim unless it's going to be, you know, something that's happening based on one of these protected statuses. So understand that up front. Now that doesn't mean that you have a license to be a jerk to people, because we don't want to have a school environment full of people who are mean to other people. But nevertheless, sometimes people start throwing out legal claims and threatening lawsuits when maybe or maybe not, you know, that there's any claim there. So there's basically two different categories of discrimination. One is what we commonly call disparate treatment. So disparate treatment is when an individual is being treated differently based upon one of these protected statuses when compared to other people who have done the same thing and are outside of the protected class. So it's individual targeting when you talk about disparate treatment. The second category is what we commonly recognize in the law that's called disparate impact. So disparate impact is when you have a rule or a policy that on its face is neutral, but when you apply that policy or that rule, it tends to disparately impact one protected class of people. Not that it was necessarily written to target any class of people, but that's just the effect that it has. So there are two different ways. We more commonly see disparate treatment claims than what we do disparate impact, but nevertheless, both of those claims are recognized under federal law. So just generally being aware of both of those. Retaliation. This is when a person retaliates, engages in negative conduct towards somebody who has done something that's protected by law. So, common example that we see, a person files with the Indiana Civil Rights Commission or with the Office of Civil Rights, the federal office, files a complaint of discrimination. And then later, something adverse happens to that individual who's filed that complaint. And a lot of times you'll then see a retaliation claim come out of that. And they'll say the reason why you've treated me in this adverse manner is because I engaged in this protected activity before, of filing this charge with this outside agency. So there's all different kinds of protected activity. If it's anything that's protected activity, meaning the law gives you the right to do it and then somebody retaliates against you, that's typically then when you see these retaliation claims that get filed. I will tell you that sometimes retaliation claims are easier to prove than what the underlying claim of discrimination is. And I'm going to give you a prime example of that. So many years ago, back in my younger years, I used to represent a lot of private sector companies, and until I moved over and started representing all public sector entities. And so back when I was doing the private sector work, I had a client at a corporate entity that had an individual who had filed a claim of sex discrimination. Female employee claimed that, that her employer had discriminated against her by not doing certain things with respect to her employment, and ultimately it was not a claim she was able to prove. The claim got dismissed, gone, over. Later, this same employee filed or applied for a promotion within the company. And when she did that, she later filed a retaliation claim when she didn't get the promotion. And the retaliation claim that she filed, she said, well, the reason why I didn't get the promotion is because they told me, if you just wouldn't have filed that charge against us, you'd have this job. So, of course, I go to the executives of the company and I say, hey, this is what she's claiming. Did this happen? Did this conversation occur? And they said, oh, no, that didn't occur. And then about 2 weeks later, and this is back, when we recorded things through cassette players, I got a cassette tape that got mailed to my office anonymously. And it was that conversation with one of the corporate executives talking with her that's saying, hey, if you just wouldn't have filed that charge, you would have gotten this promotion. So my answer is, how quickly can we settle this claim? Because obviously there's a problem. That is an example of retaliation. So while they may have had other legitimate reasons they could have denied the promotion on, it doesn't mean if somebody files a charge that whatever they want then moving forward they get. It just means that you can't take negative adverse action against them based upon them engaging in a protected act. So here within the school, where do we see that with our kids? Well, you have an internal complaint process. And Grace is going to walk you through that process here in a minute. But when a student or a student's parent files a claim through that internal policy and alleges they've been discriminated against, harassed, they have been retaliated against, then ultimately if later there's negative action that happens to the student, many times we'll draw a retaliation claim. Now, I do want you to understand, I'm not up here telling you that if somebody files a claim that they're untouchable. That's not true. You still have to be able to deal with bad student conduct and legitimately take action that you otherwise would have taken, even if not for the claim of discrimination being filed. So please don't walk away and think somebody walks off untouchable simply because they file a claim. That's a real misunderstanding that people many times will have. So please do know that. The board here at South Harrison does have a policy. It's policy 2260. And in this policy, it identifies all of the protected statuses, which also are recognized by the federal law, and says that you cannot discriminate in the educational programs and activities of the district based upon any of these protected statuses. So ultimately, you need to make sure that you're not only in compliance with federal law, but also that you're in compliance with the board's policies. And I think it's really key that you have an understanding of what this policy says. A lot of times what we're seeing right now out in the field with school people is they may see something happening that may be going on, let's say some banter between students, who are using racial slurs, who are engaging in conduct that may be racially hostile. And sometimes the inclination is, I'm going to walk this way. You know, if I don't hear it, then, you know, I'm just going to act like I can unsee that or unhear that. Well, you really can't. And so we've got to get everybody in the place where we're following the policy. If you hear it, you see it, you report it. And there's time frames and things like that under the policy that we'll go through with you today that'll tell you what your obligations are so that you know what to do if you haven't, you know, ever seen the policy before. But hopefully we can hit these highlights and then you'll know moving forward what your obligation is. So this is just another slide on retaliation. This is covered under the policy and also makes clear in the board's policy that if you retaliate against somebody for, you know, making a claim of discrimination or harassment, there will be serious consequences that will happen, and that can mean terminating your employment. So what are you required to do under South Harrison's policy? This is really important because this applies to all of you in here. Any corporation employee who directly observes unlawful discrimination or retaliation of a student is obligated, in accordance with the policy, to report the observations to the corporation's compliance officers within 2 business days. So this doesn't mean you get to decide whether or not you want to report. This is a mandatory internal reporting obligation, and you need to be making sure that you're getting that reported within 2 business days. So if you see something, even if it's something that you think, I'm not so sure, I don't know if this is really, you know, discrimination or harassment, or if you even have to ask the question, go ahead and report it to the compliance officer. I'd rather you in good faith over-report than under-report, because it's when our staff are not reporting things that they're observing and then the complaint gets filed with the outside agency that then we find out for the first time that we have employees who actually knew some of this stuff was going on and didn't report it, didn't do anything, then that becomes a problem then for the employee. Also, what you're required to do under the policy, any corporation employee who observes an act of unlawful discrimination or retaliation is expected to intervene to stop the misconduct unless circumstances make the intervention dangerous, in which case you as an employee should immediately notify the corporation employees or local law enforcement officials as is necessary for you to stop the misconduct. So you have the notification to the compliance officer, and you also have a duty to be part of trying to stop it. So the reaction of, I hear nothing, I see nothing, I'm going to play the role of being ignorant here is not going to work. So what happens then if you violate the policy here? Well, the board has established these pretty serious consequences up here, so you can be disciplined clear up to losing your job. And I will tell you that in the course of working with public schools, which has been for more than 25 years now, I can't even count how many people I've been involved in advising or directly involved in terminating over issues of failing to comply with these kinds of policies. So I'll tell you that schools don't have a choice but to take this very, very seriously, because the federal government and the state government here in Indiana take it very seriously. And if we can have penalties imposed on the corporation, then you can bet that individuals internally who aren't complying with the rules are going to have consequences that are going to come to them. So it's pretty serious. As I always say, if I know your name and you're not sitting on the board or you're not sitting in administration in this district, that normally means bad things for you. So, you know, I'm not one that you ever want to be typically on a first name basis with, because it normally means that something's happening that's not good. And I don't ever like any employee to be in that position. So I want to turn it over now to Grace, and she's going to talk with you a little bit about your investigation process under the policy so that you all have an idea of how that works.
Okay, so we're going to talk about what happens when misconduct happens and a complaint is filed and the procedures that come with it. So here we have any student who alleges to have been subject to unlawful discrimination or retaliation may seek a resolution of their complaint through 2 procedures. You don't have to do both procedures, but there are 2. There's the informal complaint procedure, which we're going to talk about, and then there's the formal complaint procedure as well. All of those individuals who experience, so students or their parents, are suggested under the policy and encouraged to file a complaint within 30 days of the misconduct. So it shouldn't be something, you wouldn't see anything that happened a year ago, because your policy suggests that it go quicker. And the informal complaint procedure is not required, you don't have to go through it before you file a formal complaint. However, the informal complaint procedure has some benefits, which we're going to talk about. Okay, so what is the informal complaint procedure? So basically, it's a process to stop inappropriate behavior promptly and facilitate a resolution through informal means. So a complainant so a student or a student's parents who alleges unlawful discrimination or retaliation may make an informal complaint, orally or written, and that complaint must be to an administrator of a building, or it must be to one of the corporation compliance officers, or to the superintendent or other corporation level employee. And whoever it's reported to, if it's not reported to the corporation's compliance officer, it eventually has to go to them. And that's who will decide, either facilitate the informal complaint process, or they will designate someone to facilitate that process. So what does this process involve? How does it work? Basically, your policy outlines numerous options for what you can do during an informal complaint procedure. First, it could be about just advising the complainant how to communicate to the concerns to the respondent. So if it's a smaller occurrence and you're dealing with a smaller level misconduct, something that can be resolved with just a conversation rather than a full out, long process mediation, we'll advise on how to do that. Now, if it's a little bit, and with that, you could also give a copy of this policy we're going over. That's kind of for your basic level minor misconducts. If it's something more severe, if both parties agree, then you may have an arrangement to facilitate a meeting or a mediation between the parties. So you kind of have your lower level, your minor misconducts, which would be more of a conversation and parties understanding what your policy says, kind of like what we're explaining to you now, a conversation about the policy, how does it work, what does discrimination mean, what does retaliation mean, or if it's something a little bit more major, you have more of a mediation, a resolution session. Now this is just for informal complaints, and remember, or the informal complaint procedure. And remember, you don't have to do informal complaint procedure at all. It may go straight to the formal resolution, but let me give you a little bit more timelines too. So there's no set timelines within which an informal complaint must be resolved. However, the corporation's compliance officer or the person they designate is directed to resolve all these informal complaints within 15 business days of receiving it. So you're going to see this as a common theme of 15 days to make sure there's enough time to resolve these complaints, but also that the school is acting promptly. If the complainant, so the student or the student's parents, and the situations we're talking about, is dissatisfied with this process, they can proceed to file a formal complaint. And also, if both parties during this complaint procedure don't want to keep doing it in an informal way, they can stop. So the informal complaint procedure is kind of like an option before it gets super formalized. You'll see it with more minor misconduct, like I'm saying, because it's it's things people can work out with talking to one another, hopefully. We all try to talk to each other, sometimes it doesn't go well. But the goal of informal complaint is this, to make it more relaxed and to find a resolution that doesn't have as much formalities. Okay. So we talked about the informal. What about the formal? The formal complaint involves an investigation of the individual's claims of discrimination, retaliation, and a process for determining whether the charges or the complaint claims in the complaint are substantiated, meaning that they're real. So what's this timeline work? They're flexible, but again, we're still seeing the policies having a day requirement, and so individuals should make every effort to file a formal complaint within 30 calendar days after the conduct occurred. So we had 15 before, now we're 30. And so how does it work? A complainant may file a formal complaint either orally in writing, again, to those people we were talking about before, principals, superintendent, corporation level officials. Now this is where you come in. If the complainant informs a teacher, principal, or other corporation employee about any complaint of discrimination or retaliation, as we said earlier, you have to inform the corporation's compliance officer within 2 days. So again, just that reminder, during the formal complaint process, it's going to be looked at that if a teacher is bringing this up or brought this up, that they did it within this 2-day window. And pass it back to Tasha.
Yeah, the only thing I would add in with regard to the formal complaint process is that sometimes the timelines do have to be flexed. And so let me give you an example of that. So one of my Marion County districts in the Indianapolis area, large district, we several years ago, although within the last 5 years, I guess it's been, had an internal complaint of discrimination that was filed, and it was literally filed on the day when school was closing for Christmas break. And so the school was getting ready to shut down for 2 weeks, people were going to be gone, families were going to be gone. This was a complaint that got asserted by a parent, but it was essentially being asserted as conduct that had occurred against multiple students. That was the allegation. So it ended up being a situation where, and they have an identical policy, by the way, to what you all have, because they subscribe to the same policy service that South Harrison uses. And they had these same timelines. And it ended up, by the time that they got back from break, I mean, we had a 2-week lag time where we couldn't even really get started because witnesses were gone, people weren't around, simply because they were gone because of the holidays. So when school resumed in January, there were so many witnesses involved in that case, and I believe they ended up interviewing like 45 people. The compliance officer did. By the time that it made it through the process, it was the end of February when the final decision then ended up getting issued. So it did end up taking longer than what the goal time frame is, so this is a goal. But sometimes do know that there are circumstances that occur that cause these timelines to have to be extended. So we handle those situations on a case-by-case basis. I know, Dr. E, you'll know this. We've had, internal complaints filed here over time in South Harrison, where it's taken longer sometimes than what these timelines are because of the volume of information that may come in, the number of witnesses, availability of witnesses, all types of things. Sometimes lack of cooperation of witnesses. So there's just all kinds of factors that can play into that. So just be aware that you do sometimes have to be somewhat flexible. Okay, I want to kind of go through the formal complaint process more or less and what it looks like in terms of once it begins, and we call them the respondent, but that's the person who's being accused. Once that complaints come in, one question that we always get is, well, you'll get it from the complainant, are you going to tell the respondent that I'm making this complaint? Well, under the policy, we have to do that. We have to let the respondent know the complaint's been made. Sometimes whether or not we'll try to keep the complainant's identity, confidential to the extent we can, but sometimes that's not possible. If there are multiple people who are involved in the complaint, sometimes it makes it a little easier, but still, in order for a person to be able to respond to a complaint, a lot of times they need to know who's asserting the complaint. But nevertheless, we do need to make sure that when we relay to the respondent what the complaint is, to give them that opportunity to respond to it, that they know that they're not to retaliate. Sometimes that complaint can be against another student or students. It varies. So I know one of the, cases of more recent times in the district has been a student-on-student type of scenario. I'll tell you right now, in a different district, I have a student-on-student scenario going on. And it's pretty tough because it has to do with a scenario where we have a parent from a different school corporation whose child plays on the football team, and it's not this district, that plays on the football team, and the parent from the other district called the school after one of the football games and said, hey, this player on your team, and identified their jersey number, and said, this player on your team used the N-word and said this to my son. And this parent's son's African American, and was very adamant that this happened, you better do something about it, is still adamant today. So my advice to that district is what it would be to any district under that circumstance, and that is you need to open an investigation under your policy, and you need to look into this. And so they interviewed all the players on the football team there at the school. There was some level of protection, I think, going on, kids protecting kids. Got my board members, retired teachers here going, yeah, I know that happens. We all know. But it was basically I might have heard something. Yeah, might have heard that. I can't remember though, like who said it, or I couldn't tell who said it, but yeah, I think I might have heard the N-word get used. Okay, and so you heard it, but you have no idea who said it. Well, if I had to narrow it down, it would probably be one of these, like 3 people. So we still have not figured out exactly who said it. We're pretty confident that it happened. We think it happened multiple times during that particular game. But nevertheless, we haven't been able to pin down exactly who did it. So that district is attempting to move forward with some proactive measures to try to roll out some training for staff as well as for students, to try to bring a level of sensitivity and awareness with regard to the issue, because this parent now from this other district is claiming not only did this happen during this game to his son, but also that this district has had a systemic issue with race discrimination within the district. And he has now gone to the Office of Civil Rights and filed a complaint, which they haven't officially notified us yet, but we've been informally notified, and we'll be going through their process now to have OCR look into this. So sometimes you may even see complaints that come in alleging claims of discrimination or harassment. It may not even be asserted by somebody within your school community, but that doesn't mean that we're allowed to just ignore it. So this was not a situation where the internal process ended up being used. I think he said he was attempting initially to go through the informal process that Grace described to try to bring resolution, and this district also has the same policy that you all have. The problem was it was hard to informally resolve a complaint when we're not quite sure that we can pin down who did it. And so that can be really, really difficult. I'll tell you, one group of employees who I think probably have the hardest time being able to pin things down simply because of the nature of your work. How many school bus drivers do we have here? Do we have any bus drivers here today? Ooh, a lot of you, okay. So you're driving your bus, right? And there's a lot of things that kids do that they shouldn't do on buses. And I know all you drivers, you're well aware of that, especially if you've been driving for a while. And the tough spot that you're in is you've got all these kids behind you, and you have to be paying attention to driving and paying attention to the road, which you should be. And it's really hard a lot of times for you to directly see anything that happens. Also, you could be in a similar spot, like what happened in this case that's going on right now that I described, where you may hear things, but you may not because you're not looking back to see who's talking, who's saying what. Maybe you recognize the voice, but maybe you don't. And so you can't know for certain who said something. But the one thing, drivers, that you can do is, the one thing that people in general, and especially kids, have trouble doing are keeping secrets. And so a lot of times they're going to tell. And if they come to you and they tell and they say, hey, this happened, this was said to me, and it was on the bus, then this procedure is going to apply. And this is true even if you are an independent contract driver with the district. You still have this obligation to follow the policies and to make sure that you're reporting that to the compliance officers. But you are in a tougher position simply because of not always having your eyes directly on everybody who is in your care at that time. And that could make it more challenging. So normally when it's coming to your attention, it's normally coming from somebody who's reporting to you. And then your obligation then is to go ahead and report it onto the compliance officers, and then let the situation be looked into. I actually have 4 claims, the last of which I just got a dismissal notice on just yesterday for yet a different district that's a different district from the football story. It's 4 kids, African American kids, spread out over 3 buildings in this particular district. And the allegations of discrimination and the alleged, physical contact that was discriminatory in nature. There were allegations of racial slurs, things like that. Almost all the claims filed by the parent of all 4 kids, they opened 4 separate cases, happened on the bus. So it is something that that happens, and many times kids decide to take their frustrations after they leave school and have it play out on the school bus. So thankfully in that situation, the bus driver did what the bus driver should have done, and that is reported internally to the compliance officer. Things got looked into, things were dealt with very quickly. It was not dealt with to mom's satisfaction because basically she wanted everybody expelled from the school. So that wasn't necessarily going to happen. She didn't like that, but like I said, we just got the final dismissal notice yesterday on the 4th case. The other 3 had already been dismissed after being investigated. But still, the school had to go through the process and the mechanics of having to deal with an outside agency that was doing the investigation on this. So just be aware that you don't necessarily have to be a teacher. It can be any employee in the district who may have to face the policy and follow the policy with regard to these issues. All right, I'm gonna kind of move through this process because basically, in a nutshell, what this does is it provides that the compliance officer has to start interviewing people, looking into the complaint, gathering evidence, and ultimately our compliance officer moves that on to the superintendent under the policy. And so the superintendent then gets the information and has to ultimately make a determination. Did this conduct occur? Did it not occur? Sometimes the superintendent may send the case back for additional investigation because maybe perhaps there's some holes in the information. And the superintendent says, well, what about this? For example, maybe a witness gets interviewed and mentions somebody and says somebody knew something. And so then the superintendent's looking through the documents and saying, okay, well, what did that person say? Oh, wait a minute, that person, it doesn't appear, has been interviewed. So the superintendent could send it back to the compliance officer or the investigator who's been appointed and say, could you look into this more? And could you interview this person? So the superintendent can do that, but ultimately, after the superintendent feels all the information has been compiled and presented, makes that determination and does it in writing. And I know Dr. E knows that when these findings get issued, they tend to be pretty extensive and pretty detailed. And so normally I work hand in hand with Dr. E on those, and we try to make sure that they're solid, because many times when it's been through the formal internal process, we have lawyers involved who are representing parties. And then, of course, we all know that lawyers just cause problems, right? Complicate things. At least that's what we always get told. So anyway, just be aware that there may be some additional investigation that may happen. If the superintendent determines that there has been unlawful discrimination, then what penalty will be imposed is going to vary. It's going to vary from case to case and depend on what the circumstances are. Obviously, the more egregious the conduct, the heavier the penalty is going to be. It could be, like I said, an employee who's the accused. It could be a student. By the same token, though, if the evidence does not substantiate the claim, then sometimes, the decision will be that here's what the evidence shows, and the evidence does not support the claim. And there could be a finding then that there has been no discrimination that has occurred. And I've seen that happen before. The most common thing I see when that occurs is you have a person who's claiming that somebody's a jerk, but they're not claiming that they're a jerk because of a protected status that's recognized by law. They're just a jerk. So it's like I've said before, if I've been interviewing people and asking about, okay, what are they doing? Well, these are the things that they're doing. One question I may ask is, well, do they do this to others? Oh yeah, they do it to everybody. Really? Okay. So like in the case of a racial complaint, well, do they treat kids who are different races? Do they treat them the same way they do you? Oh my gosh, yes, they're a jerk. Okay, so they may be an equal opportunity butthole, but it's not illegal. Now they may have a problem under conduct policies of the school, where maybe they're not treating people with respect the way that the school would expect. But in that kind of a situation where we commonly see a dismissal or the superintendent issue a response that would be, this isn't substantiated, it's not because what's happened is necessarily right under the policies. The determination being made by the superintendent is, was there misconduct that occurred that was based on a protected status recognized by the law? So there's a difference there. So there still may be consequences and a penalty, but it's not going to necessarily be because of a finding that the law has been violated. It may be just because you violated the no butthole rule. And so, we deal with those things. But that's probably the most common scenario I see where there is not substantiation with regard to the claim, because the claim really is not about a protected status. It's just because of something that's happened that makes a person unhappy, but they're not necessarily being targeted. So the appeal process. So after the superintendent makes a decision, then the complainant or the respondent, depending on how it goes, has a right to go to the board and make an appeal. So that's why we have our board members here today, because thank goodness I can't remember a time in recent history that we've had to have any of these cases go to the board, but there is that opportunity. And so based on law, the government likes for anybody who has a role at all in these issues to be able to be trained and be educated and know what to do. So that's why we have our board members today, to understand what their role is in this appeal process. So if they want to appeal, they can do that, but they have to submit a signed written statement to the board within 5 days after getting the adverse decision. And then ultimately, the board will typically hear these matters in private executive session because many times it involves confidential information that the board's allowed to meet executive session on. And then they ultimately make a decision in a public meeting about whether they are going to uphold the appeal, whether they're going to say, no, there's no basis for the appeal, but ultimately decide how they're going to act. People ask all the time, well, how can they do that, particularly if it's a student, because of FERPA, the federal confidentiality law with regard to student information, and how can they do that? Well, typically we code it. So we'll say, for example, we'll put it on the agenda as board action on student appeal 2024-1. And that would signal the first appeal in 2024. And then they vote on it based upon that coded terminology instead of identifying people. And so that's then how we do it, because we are very sensitive about protecting confidentiality of people's rights with regard to various confidentiality laws. So ultimately, the board meets with the concerned parties and their reps. Within 20 business days is the date. I will tell you, board members, that's not set in stone by the law. So if we need to flex that some, we can. But that's just the goal that you all have set in the policy. And you'll see a constant theme within the policy of short time frames, because the intent is get these claims processed and try to get a resolution sooner rather than later, because you don't want it to fester and drag out. So ultimately then, the board makes a decision within 10 days after receiving and hearing the information, and then they ultimately issue a decision in writing. Now, one thing we always need to make sure that we do, board members, is that we have that decision in a public session before then you direct the superintendent or whomever you choose to go ahead and notify the parties, because that way we don't have open door law issues and things of that nature that occur. So that is, in a nutshell, how the appeal process works. So now we're going to take a little bit of time to talk through a few scenarios. And I pulled these scenarios because they're very common scenarios that happen, and they're ones that could implicate all of you at some point. And if anybody has had anything happen that's presented in a scenario, or if you want to even raise your own hypothetical of something, please do, because this is the opportunity, I think, to talk through some of those things. So here's scenario one. You, a staff member, overhear a group of students asking another student, who we'll call student A, if she speaks English. Student A says no, and the group of students tell her to go back to Mexico. So you witnessed this happen. What do you do? Anybody want to take a stab at that? You hear this occur, or you see it, or it gets reported to you and you know about it. What do you do? Yeah. So he said that you approach the group and you explain to them why this is not correct, and I think that that's really good. Definitely that shows that you're trying to intervene, you're trying to stop the misconduct. What else do you do with regard to the policy when you see something like that happen that's racial in nature? Yeah.
You got 2 days to report to the compliance officer.
That's right. 2 business days to report to the compliance officers. Good job. Yeah.
Now, if you approach the group, do you determine yourself that it is set up, is it taken care of, or now what?
That's a good question. So the question is, what if I intervene, which the policy expects, that our staff will intervene and try to stop the misconduct, and what do I do if I feel like after I've intervened that that's been effective and that the conduct has stopped and I've taken care of it, basically?
That's what it can be complicated. Everybody knows everybody's parents.
Yep.
What we call your dad, stuff like that.
Yep.
That can be set up way.
yeah. So the point being that everybody knows everybody in the community. A lot of times you may know the parents of the students who were involved. You may feel like, hey, I've intervened, I've taken care of it. You know, should we let it settle here? What I would do in that instance is I would still go ahead as a notice and send a message to the compliance coordinator, not because you're saying, I think you need to do something. You can just simply say, I'm sending this information on to you, here's what happened, here's what I did. I feel like it's resolved, I think I handled it and have basically squelched it, but I still wanted to put it on your radar. So why do that? Well, because let's say that something happens later that's a continuation of what happened or somehow gets tied back to it, nobody at central level is surprised because you've gone ahead and put it on their radar. Now, they may not, in that situation, open an investigation or anything because they don't necessarily have to under those circumstances, but at least if something comes later that it elevates it, then they'll go, oh yeah, you know, we got this report, so we're not surprised. We knew that some things had been happening, and then we'll not be caught off guard. So very good. Those are really, really good answers, and you guys definitely understand the policy. What happens if you don't do anything? Yeah. All right, compliance officers, stand up, please.
Like there's more than
Yep, yep. Yeah, we've got another. Okay, yeah. So these are our compliance officers in the district. They are also identified by position title in the policy, along with contact information in the policy. So all of the policies are online, and they are available and accessible to anybody, including people outside of the district. So if you go to Policy 2260 and you take a look at it, it will identify the positions, the few positions, and we have multiple compliance officers, and there's a reason for that, and I'll tell you in a second. But you can report to any one of them, and you'll see the contact information for them so that you can follow through with that. Here's why we have multiple compliance officers. Because what happens if the alleged misconduct is against a compliance officer? Who then looks into that? You're going to ask them to look into themselves? That's probably not a very effective process. So what these outside federal and state agencies expect us to do is to identify multiple avenues of people to report to so that, you know, hopefully one of those people would be disconnected and not have any involvement. Also, sometimes we may have a bias situation or a bias claim where maybe one of the compliance officers might know like one family or the other pretty well, or maybe be friends, or maybe be family. Happens, right? You know, I always say, people ask me all the time, they always say, how do you handle all these relatives who are employed by your schools? And I go, what do you mean? And they say, well, don't they have anti-nepotism policies? And I said, if they had anti-nepotism policies, we wouldn't be able to staff the school. Because, you know, and I know, I mean, I graduated from a small community in Yorktown, Indiana, and you know, we had a lot of people who were related who all worked for the school. And so, you know, we've got to have people who run the building. So sometimes you get these connections, but that's why we have multiple options. So again, what happens if in this case you don't do what these folks over here said, which is correct? What happens if you don't do that? Is there a hand up?
I just have a question.
Yeah.
If you are an IA and you have this incident happen, do you take matters in your own hands, or do you tell higher up before you actually say?
Yeah, so the question is, if you're an IA and you have a reporting chain up above you and you see or hear this, do you take care of it and intervene yourself, or do you send it up the chain? I think a lot of times it may even depend on the circumstances. But if it's something that's happening right here in the moment and it needs to be squelched, then the policy would expect you to intervene and try to stop that misconduct. Now, the policy would also expect that you would then report it up the chain as well. So if you're an IEA, you would want to make sure you're looping your teacher in to that conversation, that you're going to your building principal, looping your principal in, and then a lot of times building leadership then will contact central level and do that. You can also reach out to one of the compliance coordinators and make them aware as well. But that's a really, really good question. If it's something that you don't see directly or there's something happening in front of you that you need to disband immediately, then you just kind of hear about it. That might be something that you might want to run up the chain of, hey, this is what I'm hearing. I want to report it so that somebody can do it. Go to a compliance officer. I would also make sure to loop in your teacher who you work with, as well as the principal, just so the key people are in that loop, and then they can decide at a higher level how they want to proceed going forward. But that's a great question. All right, so everybody's avoiding the question of what happens if you don't do anything. Yeah.
Very bad thing.
Very bad things. You become on a first name basis with the board's attorney, and that's not good. So that's right, very bad things. In fact, depending on just how bad those things are, it could be that we're having a conversation that's going to, result in you not working here anymore. So we don't ever want to see that happen. And these are really pretty simple steps to take. A lot of times the resistance I see that staff have to not wanting to report within the 2 business days or not wanting to intervene is because of the personal connections within the community, and feeling like they're going to make this person mad or that person mad, or sometimes there's just a feeling among school folks of, I don't want to be involved, and having more of a passive type of a nature about them, that they don't want to be involved. And, I say, see something, hear something, report. That's what you need to do. And so we need to be treating this like how we by law have to treat child abuse and neglect. Because in Indiana, if it's child abuse or neglect, and you hear something, you see something, whatever it is, and you don't immediately report to DCS or to law enforcement, that's a crime in Indiana. So, this isn't rising to the level of a crime like what it is with abuse and neglect, but it's very, very important. And trust me, there is nothing worse than having to be sitting down, because when you go before some of these judges, they're standing like high up like this or sitting high up, and when they're looking down at you and they've got their glasses down a bit, it is not a comfortable spot to be in. So, especially when it's in the federal courts, and a lot of these claims are in the federal courts, which is where most of my cases are. So just trust me, you don't want to be subject to that scrutiny by any outside decision maker, and certainly not by judges. That's then when it could be really bad. At a basketball game, you, a staff member, overhear a student A is a problem, right? Call another student, student B, a racial slur. What do you do? This is similar to the football case that I have going on right now. It's a real life case. Anybody? What do you do? Come on, you guys know this. Yeah, in the back.
The same policies apply at extracurricular school-sponsored activities that they do on school day, so you still intervene, you still tell them we don't do that, try to explain, see the error in their ways, and then cover your butt with a report.
That's right. That is great. So I really loved what you said straight out of the gate there. Just because it's an extracurricular activity doesn't mean that you don't have to comply with the policy. It's still a school event. So even though it may not be during the regular school day, it may be an ECA, it may be a club event, it may be, something else other than actually happening during school hours, It does not alleviate, as she said, your obligation within 2 business days to report, your obligation in the moment to intervene, if it's something that you can intervene in, and take that action to try to stop it, and make sure that you're reporting. If I were you, I would report in writing, even if it's something as an email, so that you, in your words, and I love it, cover your butt. You want to make sure you do that, because then if this issue blows up into a much bigger issue later and somebody else dropped the ball on the chain, you can say, look, I made this known. Yeah.
Not that would apply to this, but a lot of kids do a lot of trash talk on the court, on the field. You have to differentiate what's acceptable and not.
So the question is, there's a lot of trash talk that happens between kids, and that sometimes, should it be a situation where you differentiate between what is maybe acceptable versus what's not? I will tell you this, in any situation where it's anything that is racial in nature, anything that is derogatory, that's within any of the protected statuses, my response to that is, that's serious.
That we were using racial a lot, is there anything else? Because we had several.
Yeah, there is, and we're focusing on the race piece today simply because it's become a very prominent claim. And so we want to make sure it's on everybody's radars, but it could be like a different federal law that covers gender discrimination is Title IX. We hear a lot of that buzzword right now, right? Title IX, Title IX, Title IX. That's another area that has to do with sex discrimination. So you hear people making comments about one another that's derogatory in nature because of somebody's gender. Or the big thing now that we're seeing a lot of litigation on is over transgender, which now in our jurisdiction has been recognized as protected under Title IX by the federal courts. So yes, it could happen with other protected statuses as well, but the bottom line is, regardless, if it falls within one of the protected statuses, which you saw on that very first screen that had the list, if it falls in that realm, then you need to take it seriously. And even if you know the kids, even if you think this is playful banter, I will tell you, I had a Title VI case that made it to federal court, and it was over a group of kids in a friend group who were texting back and forth, and they were using the N-word, they were, just calling white kids crackers. It was all these derogatory racial slurs. They were all buddies in the group, and it was a mixed group of races. Okay, so nobody knew about it because this is all just good and fun until one of the parents of one of these kids looked on their kid's phone and saw all this. And one thing that was in this chain of communications was a photograph. It was, cartoon kind of thing, but it was a person who was standing over a well holding a chicken in a noose and dipping it in the well and saying the N-word over and over and over. This parent did not take kindly to that. We ended up in federal court over that. So, even if you think that, oh, this is just a friend group engaging in banter, doesn't mean we shouldn't stop it, we shouldn't do something. Because you never know who's going to make that claim. And then ultimately we're going to be answering to an outside authority. Yeah, in the back.
So I have many white children in my class, and pretend the other day someone called another white child, one white child called another one the N-word. Obviously, this child doesn't fall under that particular race, and we have kids that call each other gay or whatever, even when they're not. How does that apply to your case?
Yeah, so that's similar to the question that you were asking. So what happens if a derogatory term is being used and that term, as it's being applied to whoever's being targeted, doesn't even fit, what is commonly, how that term's commonly defined. And that goes back to, sometimes we hear people complain that, well, how come, like this race can't use this word, but this race can use this word about itself? I don't think it's still right. And the problem is, if you don't stop it and shut it down, like I said, it's like that case we had with the friend group. Nobody thought anything of it until, and now one of the parents got a hold of it. And then it turns into a federal lawsuit. So I think you still shut it down, even if they may not be using the term as its common meaning. It's still not intended to be positive. And sometimes maybe they even think it's funny, you know, and they're like these other kids, they're bantering with each other. But ultimately, here's how that looks if you do nothing. You end up in the situation like what some of the school staff at this district that we had the federal claim come, who end up being hailed in as witnesses and deposed. Did you know that these kids were bantering this way? I did. And you did nothing? I mean, you're on the hot seat then, you've got a court reporter sitting there recording your testimony, and it's not good. It's not good for you, it's not good for the corporation. So I think we still shut it down. That's a great question, yeah.
So on that directly, even if it doesn't apply to the person it's being said to, you never know who's in their family, you never know about their parents, you never know
That's
about
right.
their grandparents.
That's right.
And then if I understand things correctly, that could actually end up being.
Yes. Yeah, that's exactly what happened in that case with the friend group bantering. It wasn't any of the kids who made a complaint about one another. They were all buddies. It was when the relative outside saw it on the phone and didn't appreciate it and said this is inappropriate.
And I meant that somebody in their family could be in the protected class.
Yes. Oh, that's true. Yes. So actually, it's funny you say that. He said, so maybe if the kids who are involved in using the inappropriate derogatory terms are not in that protected class, but they're using those terms, what if there's a family member who is in that protected class? That is the football case I'm dealing with right now. The student actually is African American. The dad is Caucasian, is white. But mom is African American. And so it's actually a white parent asserting a claim of racial discrimination against the school. And you say, well, but they're white, but they still have a right to assert that claim because they're saying that these racial slurs were stated and this should not be happening, and the school has an obligation to do something about it. Happened at a school event, under school supervision, something should have happened. That's a great point, because that happens a lot, especially today, because, you know, we have a lot of blended families, and including extended families. I mean, sometimes we have extended family members who are taking care of kids who are in your care every day, as opposed to it being a traditional two parents and, you know, type of household. So you never know who you're going to be dealing with. And I think if we just deal with it by shutting it down, this is inappropriate, this is not how we talk to one another, this is not how we treat one another, making sure up the chain that they're aware and putting it on other radars who are in administration. That is what I think we can do to best try to protect all of you, as well as to protect our kids and protect the corporation. Very good questions. What's that? Ah, yeah, in the back.
So this is definitely race-oriented, but what I'm hearing a lot from all kids is stop being autistic, authenticity. Is that the same, or is it something totally different? It's like the new art.
Are you saying autistic kids who are making the derogatory comments, or people are making them about autistic kids? Great question. Ah, okay. But using it in a derogatory way. Yeah, I think you shut it down. Because if you look at the list of protected statuses, disability is one of them in that list. So you can bring a claim for, you know, inappropriate conduct with race, with gender, with disability. with national origin, you know, all of those things that were listed in that first slide, all of those are going to be problematic, and you definitely want to intervene and stop that. Thank you for raising that, because you're right, that is another common one. Yeah.
Question, the other day, this was a freak accident. I referred to a child as a girl, but wasn't an actual boy, I did not know. How would you protect yourself from anything happening where it can be turned into a accident?
Sure. So the question is, there's a situation where employee thinks that a student is a girl, refers to him as a girl, but then later learns that the student is a boy. Okay. When it's inadvertent like that, I think you still, I mean, the first thing I would do if I were you is talk with, if like you're in an aide position, talk with your teacher, talk with your principal, your building leader. That's not a situation where it's intentional, that's a mistake. You know, mistakes happen. I mean, we all make mistakes, and today with, you know, just somewhat of, you know, clothing that like both boys and girls can wear, or maybe even fashion styles with hair or whatever it may be, that can, you know, basically transcend gender lines. That's not necessarily an uncommon mistake, but I don't think you're going to burn for it. So what I think it is key is having the conversation with your immediate supervisor as well as your building leader to say, hey, let's talk about this, and is there anything maybe we should do to be proactive and try to prevent this from becoming something that it was never intended to be. And so let's say, for example, you have a really strong rapport with somebody who's linked, or a parent or something, to one of the kids. Perhaps in that instance, you know, you all might feel comfortable reaching out and just saying, hey, this happened, we just want you to know it was a mistake. But ultimately, I think you handle it case to case, and I think you do that by reporting up to your teacher, your building level leader, and then seeing collaboratively how you should address it based on the circumstances. That's not going to be a one size fits all, but you're not going to get in major trouble simply because you made an error that was an honest error. Yeah.
I have a question on the banter. Are we required to, if we have a meeting and that banter doesn't hear, is that something we're required to report within 2 days?
If you hear the banter, yes. So you're going to at least want to report that for sure. You want to intervene and stop it if it's playing out in front of you. So it's different if you're not witnessing it playing out, but you know about it. So if you're witnessing it, it's happening in front of you, you want to try to intervene to stop the conduct, and then you want to report within the 2 business days to the compliance officer. Even if you think it's resolved, still, like I said before, you want to make sure you put it on the compliance officer's radar just in case it resurfaces later, then they're not going to be caught off guard. If it's a scenario where you're not watching it play out in front of you, but it gets reported to you, so somebody comes and confides in you that, hey, you know, this is going on. A lot of times, our kids will have special relationships with certain staff members, and they'll feel comfortable confiding and talking with them. If you have that happen, then in that case, you're not like immediately intervening, so there's nothing happening right in front of you, but you are then within the 2 business days making that report. And then that way, you know, the people who are in those positions in order to handle those situations can then step in, and you've done your duty because you've sent it up the chain. So I see Dr. E over there giving me the eye. That normally is the eye that means, Michelle, please be quiet. So I want to say thank you all. We didn't even get through all of the scenarios, but you all asked all the right questions. You posed all the right real life scenarios. Happy that we were able to be here today. Hopefully everybody will take some nuggets out of here with them. And you and I will never know one another on a first name basis, and that'll be a great thing for you. So thank you so much, everybody.
Thank you so much, Michelle. We appreciate it. If you do have those painting questions that you did not get to ask, shoot me an email. I'll forward it to Michelle, and we'll make sure you get an answer to that question. Again, thank you so much, Michelle and Grace. We're very, very pleased that they're able to join us today and share this information. So now we're going to break.